morning. It is important for FERA to create opportunities for its members to meet during the year and discuss issues that directors are faced with at a national and an EU level, to stimulate our European network. And today, thanks to Slovenian Directors Guild and AIPA, who host us for this workshop, the first of its kind, we are able to meet and discuss how the different solutions for collecting the right holders' money is organized in some of the European countries. During FERA's last General Assembly in Malmö, our members heard about the Nordic directors and their experience on TV series. This time, our discussions will not focus on our craft as directors, but on our rights, how we manage them, and how we defend them in the best way. Our members have always had a keen interest in collective management of their rights and how it must promote their best interest. This workshop aims at giving our members pointers in their discussion with their local collective management organizations on how that can be achieved. By informing them about what really exists, we have our morning session, the case studies, and about the new European legal framework that their CMOs have to fit in since the new directive publications in 2014. We then have a sum-up discussion on what do directors want from their CMOs in this new context and how to best achieve it. In the context of a growing influence of internet and digital technology in the way our films are shown, and also of an upcoming reform of copyright at the EU level. It is important that directors find the best way to manage their rights and, as the primary author of an audiovisual work, assert their position within collective management schemes. All the good examples from some of our member states have a tradition and a history that can be of good help for others to hear about and hopefully find useful in their own struggle for setting up CMOs that really are going to take care of, in the best way, organizing how the authors would get their money. We also, of course, have some example of how and why things have gone wrong. We can all learn a lot from these examples to make sure that these mistakes doesn't have to happen again. So thank you, Slovenian Directors Guild and AIPA, for arranging this seminar, and we hope that this will be the beginning of a fruitful cooperation in years to come. Now I would like to give the floor to Natasha Bučar, Acting Director General of Media Directive, Ministry of Culture, and Dr. Igor Kočić, Consultant of the Minister of Culture.
Yes. Good morning. Great to see you here. Prepare for 1 hour speech. No. Natasha Bučar and me are here in the name of the Minister of Culture. And the Minister of Culture has asked us to wish you welcome and good work. I'm personally very happy as some kind of a veteran in FERA that this is taking place, and I'm grateful to AIPA and Slovenian directors for organizing this. And this is it. I hope you will have a good stay and successful work. Natasha is going to tell you something about what we do at the ministry.
Hello, ladies and gentlemen. Welcome to Ljubljana, Slovenia. We are glad that experiences in the field of collective rights, especially from the film director's point of view, will be discussed and exchanged here in Slovenia. The workshop will be probably raising important questions about the management of collective rights precisely in a time when we have in front of us a proposal of a new Slovenian law on copyright and collective rights, which will be discussed in Parliament next week for the first time. Recently, we have heard statements of the National Council for Culture, an independent body that directs a national strategy for culture, for the Ministry of Culture, who has drawn attention to a number of problems in the field of copyright and related rights. Ministry of Culture is aware of the problems and will work in the direction of legislative changes that will address these problems, especially the rising transition of personal rights in corporate right, which is a huge problem for the authors in the audiovisual sector, especially as the National Council for Culture recently also announced and confirmed this is true. I would like to thank again the Federation of European Film Directors to organize this workshop here in Ljubljana, and also the Slovenian Film Directors Guild and AIPA for hosting the workshop. I wish you a successful and fruitful day and a nice day in Slovenia to all the international guests. Welcome.
So I welcome up Gregor Štibernik, General Manager.
Thank you again for all of you for coming to Ljubljana. I hope that you will enjoy today and today's evening and the day and tomorrow. And I hope that you enjoyed the reception last night. My presentation about AIPA will be very short because it's at the end of the day, it's all about the law, and the lawyers will do the talk, and after the lawyers will do the talk, the general managers are here to take the money, which belongs to you, to the authors. As some of you remember, last year in Sweden, in Malmö, I did a very short presentation about AIPA. AIPA is a collecting society of authors, performers, and film producers of audiovisual works. I am the general manager. AIPA is a joint collecting society. Under one roof, we have three different categories, and we have authors, co-authors, we have performers, and we have film producers. So AIPA's got three general assemblies, and we administer the rights for co-authors for cable retransmission and blank tape levy. And according to the law, performers and film producers are entitled only to get the money from the blank tape levy. We are operating now for 5 years. We will celebrate the 5th anniversary in October. We have more than 500 members, and we collect from cable operators. We have more than 60 cable operators. Out of them, 5 are very big one. They have more than 80% of the market. The other 55 are small users, small scale cable operators. And later on, Borut, when he will be giving a lecture, will tell you a little bit more about blank tape levy and why we are not collecting it at the time being, and I hope that we will collect blank tape levy again soon. Our corporate structure is like that. We have managing board. It is consisted out of 7 members, 3 co-authors, 2 film producers, and 2 performers, 2 actors. We have supervisory board. It is also consisted out of 3 co-authors, 2 film producers, and 2 performers. And as I said, we have assembly of co-authors, and this assembly appoints delegates to the managing board and supervisory boards, as well as assembly of performers and assembly of film producers do. The members are elected for the period of 4 years. We have no yet distinction between members. We have no classes of membership. So everyone who's got the rights, who is a right holder, right owner, can be a member of AIPA. That's about the structure. Now I will give you some figures before I will finish, and we'll let, I think Špela is the first one do the speaking. Our income is like that. We gathered for 2014, we gathered roughly 3.5 million euros for co-authors for cable retransmission. So we are collecting approximately 1.75 euros per capita per year. As I said, we have a right for blank tape levy as well, but we are unable to collect it right now. Borut will tell you into details why we have that kind of situation. But the last time when we were collecting, we collected 500,000 for all three categories for audiovisual. We collected like 200,000 euros for co-authors, 150,000 for producers, and 150 for performers. This distribution is according to the law. According to the law, we must distribute the blank tape levy money as it is written on my slide. As you can tell, there is a slight, there was a slight progression of the income. We have a general agreement signed with users, with their representatives, with the cable retransmitters union, and I think that business goes relatively smoothly. We don't have many big problems with that, so they're paying. Later on, I think Špela will tell you also about our intention to cover the others' rights too, because as I said, we only collect for co-authors right now, but we applied for the license to collect for the authors of contribution as well a couple of years ago, and we are still waiting for the intellectual property office to give us that right. If we will, and when we will get that license, maybe it's better to say like that, we estimate that we will be collecting roughly about 5 million euros per year for cable retransmission of audiovisual works.
Hello, everybody. I'm Špela Grčar. I'm outsourced legal advisor, lawyer for AIPA, working for them for about 3 years now. I would like to present you very, in a way, problematic provision of our law, legal presumption, which is, according to the wording, in benefit of film producers more than co-authors. The authors that contribute somehow more or less to the audiovisual work are recognized by our law in closed circle. Only these 6 authors are recognized as co-authors. The 7th one is conditional. If it goes for the animation part of the audiovisual work is essential for the film, then the animator gets the co-authorship too. Further on, we have authors of contribution that are recognized by law, but their position is not so strong. So the law says that they only have rights on their contribution, and that's also the position of our intellectual property organization office, which we kind of don't agree, because they stay without any remuneration or royalty after their contribution is included in the audiovisual work. Our law then goes further and says the legal presumption for the co-authors covers after they sign the contract, and by signing the contract they assign to the film producer exclusively and without limitation all their economic rights and other rights, not only to the audiovisual work but also to its translation, its further possible audiovisual transformations, and photographs made in connection with the work. And
the law says unless otherwise provided by the contract. For the authors of pre-existing work, when the audiovisual works are not originals, based on the original screenplay, and for the authors of contributions, provisions of the law are similar. But, as I told you, the last condition of the wording says unless otherwise provided by the contract. For the co-authors, usually never is. The contracts never, almost never, have different different transfer of rights than it's provided for in law for the film producers. So even if co-authors sometimes want to negotiate or retain certain rights, they are weaker party and they are not successful with such requirements. So we have also very, in a way, not unfair, but not really good legal regulations about their the trade unions that can be an option for cultural authors because they are recognized as self-employers, and employers as such cannot have trade unions. So they cannot gather in a way of assembly or otherwise than as a guild or as a society or a club. And as such, they don't have such strong position when trying to negotiate better conditions in the contract. So at the end, they don't get much. They only get certain unwaivable rights that they're written down in law, which are obsolete in fact, in practice. For example, the third one that says that co-authors retain the right to claim equitable remuneration for each rental of videograms. We all know that the videothèques are no longer existing, so this is something that in practice is not working. And even when the videothèques were, as I was told, not many of co-authors got any of the remuneration. Our law has certain, let's say, safety belts for the co-authors, but they do not work. There are provisions in law that say, for example, that for each transferred right, a remuneration has to be defined separately. So I haven't not seen the contract that would have such clause. And then further on, for example, film producers must at least once a year report about the revenues they get from the film exploitation or audiovisual work exploitation. And this also doesn't happen quite often. Maybe I don't want to make a general statement. Maybe there are film producers who do that, but in general, I can say it's not really something that works. Then we have other safety belts by law, which are also not in favor of co-authors because they force co-authors to be active if contracts don't work for them. They have to, of course, go to court. And this is something that is financially very expensive. Certain authors certainly don't like to go to court. They actually just say, okay, well, leave it at that or so. So in general, these provisions of law that are meant to kind of guard co-authors or other authors of contribution, or they do not work. So in real life, as I told you, all these unwaivable rights demand court procedures, and because of the financial and also timely effort, co-authors don't decide to go to court. That's in general. Authors also try to negotiate, as I told you, when signing the contract, and say, well, can I retain such and such right? And they usually get this clause, take it or leave it, because there are always other people standing in line to get the job. So they're kind of frightened, and they usually don't go further. I can tell you about our situation before '95, because it's very important. When a country decides to renew a copyright law, for example, they need to also think about how the practical situation is, what is going on the market, and they need to take into account also the history of the rights, or of pursuing the rights. So our situation before '95 was that our law did not have such whole presumption, such presumption that would take all the rights from the author. The old law did not recognize also for a cable retransmission right, so that means for the works created before '95, the authors, co-authors, retained or got the right, so they still can have certain benefit out of it. But the authors, or the authors of the work after 1995, they just don't benefit from that presumption. So also I got I got a chance to look into, I don't know, about 100 of contracts for the last 3 decades that were, and I discovered that contracts used to be much more fair and equivalent, because film producers they got only the rights that were really necessary for their work. They didn't get the so-called secondary rights, if we would say, or they gave co-authors a chance to get some remuneration in percentage after, I don't know, certain period when the work was used by a film producer for a certain period, let's say 5 or 7 years. After that, the co-authors were, they got a certain amount of remuneration for film exploitation. Or they got certain percent of exploitations out of TV licenses or so. So, in my opinion, contracts before were much more fair and equitable for co-authors than they are now, when they actually just take the legal presumption from the law and just put it in the contract. So, my solution, after reading all these materials, the contracts and everything, was that the situation should be much more fair than it is now. And my solution or recommendation is that, of course, legal presumption for film producers in these days are very are necessary, and the film producers, because they also have economical risk for the projects of audiovisual works and everything, they need to have rights, of course, but co-authors or authors of the contributions or of pre-existing work need to have some benefit out of it too, and not only by signing the contract, but also afterwards. So my recommendation would be that the situation with authors of audiovisual work would be similar to the one that have musicians with with the small rights, so-called small rights, because it would first of all it would put the pressure between direct contact between film producer and co-authors out, and it would leave it to collective society. And my proposal would be that such remuneration would be collected mandatory by collecting societies. So this would leave out the film producers and authors, and they would not need to negotiate anymore. There would be no stress, no tensions or so. So I think this would be a good solution. And I offer this as a conclusion of my my presentation, open for the discussion afterwards. Thank you.
Hi there. I'm the unlucky son of a gun who drew the shortest straw between all the panelists and got awarded with probably the most boring topic for today's panel. Private copying. Come on. Everyone knows what is private copying. Everyone does it. Everyone uses it. And the ladies at the back on the computers can be doing it right now. But in order to fully understand this, where are the principles behind this right, we should dig a bit into the history, so I apologize if this is going to be boring, indeed, but we have to do it. So let's start like this with a fairy tale, once upon a time. And because audiovisual field is pretty complex, let's stick to much simpler part of creative world. Let's stick to music. So in the ancient times, the music was transferred, one musician listening to another, or one musician teaching another. There was no written form of it, and even if there were some written forms, they were usually put into books. This, you know them from the museums and archives. These huge books, very thick. It was impossible to carry them around. So it was transferred basically orally or by ear. But in 15th century, this guy Gutenberg invented the pressing machine. And it is funny that this is the machine that caused the revolution in that time. And this was the product of the music from that time. But apparently this was very expensive commodity, because only 100 years later, Tilman Susato established first music publishing, let's say, business. Why do we estimate that this was a very expensive commodity? Because we are not sure that Tilman Susato, in fact, was the publisher. He can be the author, the composer, but the quality of his works is so one work differs from the other so much that actually we assume that actually this is not his work, but actually he was just a publisher collecting the music from the composers and selling it under its own brand. This chap had to rewrite his own works in order to distribute it. But we people are hedonists and we like to enjoy our life with all our senses. And that is why we are very creative in trying to obtain all these luxuries. And of course, the technology went on, and in, I believe it was 1877, yes, it was Edison who invented a phonograph. This is actually not his first phonograph, this is the second version of the machine, but as you see, it's pretty big and very unpleasant to see. But this was the first invention, and it enabled to the people that they actually were able to hear something that was produced somewhere completely out of their physical range, from on the other part of the world. And in that time, the music performers were on a good, very good ground, because the problem of this machine that was later upgraded by Graham Bell, was that actually each of these valves, you can see it there in brown, had to be recorded. It was a unique piece, and it had to be recorded all over and all over again. And it was the producer of the machine who was interested in recording these valves, because if they wanted to sell the machine, they had to offer to the clients something to listen. And the technology went on, and soon they discovered the means how to create the master, so-called, so the master recording, and from that master they made copies, and these copies were made, were sent all over the world, so actually we could enjoy, let's say, here in Europe, the music from down under or from the States. And in those times, it was still quite okay for the performers, because the quality of this sound was not that good as live sound, and it was impossible to copy this. But the technology went on again, and we got the magnetic tape, the cassette, so-called. The sound was still not perfect, but it was cheap, and it was possible to reproduce it at your home. And in that time, this was the trouble, because more and more people opted to buy one cassette and then reproduce it. So the people who were involved in the creation of the cassette, so the author, the producer, and the phonogram producer, did not get any money out of this. And that is why blank tape levy was introduced. The system went on, and it became even worse. Philips introduced CD, and with this you get the sound that's pretty much alike to the live sound. Okay, now we can argue about this, but let's say it's pretty much the same. And in your field, the audiovisual field, it got even worse. Blu-ray. Before, it was not possible to put a quality film on the whole film on the CD, but Blu-ray could do it. So it was possible to do it in the factory, and later on even at your homes. And situation even worsened with the fact that actually when you were creating the copy of a film, you actually were making a clone. There was no degradation in the quality itself, but actually you got the same quality as it was put on the original disc itself. And we got blank tape levy. Blank tape levy was introduced, as I said, in the 60s in Germany, and it still is the target of different objections, like saying that actually it's a pauschal thing, it's a lump sum thing, that actually is not following the real use of the protected repertoire, let's call it like this. But, and the phonogram industry, I'm working for phonogram industry for, I believe, for 12 years now. Some 8 years ago, on the meetings of the phonogrammic industry, they were telling us that actually blank tape levy is just like peanuts coming from, I don't know, for some time, and it will die very, very soon. But as in many other fields, you know, the phonogrammic industry is a kind of an old dinosaur who is just following the technology progression. They were wrong. And because the scope of devices that were actually able to reproduce and so reproduce in a way of copying and playing back, actually this expanded vastly, you know, from Walkmans we came to iPods, to mobile phones, to iPads, to tablets, all kinds of stuff. Now let's go to Slovenia. So, blank tape levy is collected actually from 1997 on, was collected from 1997 on, and it stopped in 2006 when the company who was carrying the license said that they're not playing this game anymore. And in the same year, our government adopted a governmental decree on the tariffs that actually is quite good. Not about the prices, not about maybe the system, how the tariff for each and every device, appliance, or carrier, let's say, is calculated, but it is very good in the spectrum of all devices and all the carriers that are included in this decree. The trouble with our blank tape levy, as Gregor mentioned before, is that the last license, temporary license to collect this levy was issued in 2007 for 2 years, for 2008 and 2009, and from that time on, the right holders have just long noses, because for all these years, there's a running procedure in front of our intellectual property office, and the conditions to get the license are more and more strict and more and more impossible to fulfill. So we don't know where we stand right now. And now let's go to our what actually private copying consists of. This is one of the articles from our copyright law, and as you know, the private copying actually is exercising the right to reproduction. This is, don't bother with the small text, I just want to brag a bit that in Slovenia we do have laws, even though the situation is not so nice on the field of private copying. But actually our law says that reproduction is free if it is done by a private person with no more than 3 copies, just for her private use, if it is not available to the public, and there is no economic gain. But actually this is more or less a commercial trick. It is not free, because the law just said that the end user is not the one to pay it to the right holder directly. He's paying this through all of this. So the manufacturers of the appliances, manufacturers of media, and importers. So now we have to speak what the future brings, because there are facts against blank tape levy, and these facts are these. So the sale of physical media is in decline for quite some time now, and let's say the industry, audiovisual and music industry, is complaining that these figures have fallen so low that actually it's just a question of time when actually are going to become so low that it's not going to be maybe economical to go on with that kind of distribution of audiovisuals and music. The technology is still expanding. We have more and more different media, different appliances that are invented just for this purpose, just for this business. And there's a vast move of the use to the mobile devices, so the tablets, the mobile phones. Mobile phone is going to dominate our lives in next 10 years, so they say. So the pictures like this at our homes, you know, hamstering everything on one place. Now record this, record that, store this, store that, is probably going to end, because the next fact is the hamsters are the endangered species, period. Why? Because everything is moving into a weather area, into the cloud. And in the cloud, you don't have the control anymore, and it is not treated as a private copying anymore. So, what should we focus on in the future? We believe that the liable persons, up to now we were speaking about the manufacturers and the importers only, but actually I believe we should speak about the persons or the private entities who are offering the service of putting the things in cloud. Why? The cloud is private copying. I'm making a copy of a protected work of audiovisual, let's say, and instead of storing it onto DVD, onto USB dongle, onto my hard disk, I just put it somewhere else out of my machine, but actually I'm doing the same thing. I'm just storing it on the other place. And of course, the other issue is, while analyzing the systems throughout the world, we see that there's a huge difference between the appliances and the carriers that are included in the blank tape levy scheme. So actually, we should opt for as broad definition of the appliances and the carriers as possible. And here my presentation stops. So now it's up to you. Now you are the ones who run the negotiation and who are going to be responsible on how the system goes on. The rights are yours and you have to take care about them. Thank you.